Welcome, and thank you for joining Seyfarth's webinar presentation on responding to the Donohue dilemma. All participants are in listen-only mode. If you have any questions throughout the program, please use the Q&A section located on the right side of your WebEx window. We will do our best to try to get to everybody's questions, if possible, during the presentation. But if not, we will be sure to follow up with you via email if we don't have a chance to get to your questions during the webinar itself. For those of you that are interested in CLE credit, an attendance verification code will be read during the presentation. Please write the code down. It will not be repeated, and it is required for CLE presentation. The presentation is being recorded, and a slide deck can be distributed to any of the attendees in the following days if people are interested. My name is Andrew Paley. I am a partner here in Seyfarth's Los Angeles office. I am also the head of our California Wage and Hour practice group. With me today are two other members of our group, Elizabeth McGregor in our San Francisco office and David Rosenberg also down here in Los Angeles. Quick little legal disclaimer. This presentation is for informational purposes only. It should not be construed as legal advice. If you do have questions, please feel free to contact us directly or any other legal counsel that you might have. We'd be more than happy to talk to you about any specific legal issues that you have concerning this issue. So in terms of today, our agenda, we are going to cover a quick summary of the Donohue decision and what the key holdings were. Talk a little bit about the rise of the rebuttable presumption with regard to facial violations of meal break time punches. Then we will be talking about how to rebut that presumption, practical solutions and common applications, and round it out with best practices with regard to meal and rest periods, rounding, and timekeeping attestations. So with that, I'm going to turn it over to Elizabeth, who will get us started, and she will kick us off talking about the Donohue decision itself. Elizabeth?
So just to briefly go through the facts, the plaintiff in this case worked as a nurse recruiter for AMN. And AMN was using a timekeeping system that rounded punches at both the start and end of shifts and at the start and end of meal periods to the nearest 10-minute increment. So for example, if somebody was clocking out for a meal period at 12:02 p.m. and then clocked back in from the meal period at 12:25 p.m., the meal period would round to look like a full 30 minutes, even though it had only been 23 minutes and was thus short. And similarly, if somebody clocked in for the start of shift at 6:59 in the morning and clocked out for a meal period at 12:04, it would again round to look like the employee clocked out right at the 5-hour mark, instead of showing a late meal period. So AMN was using rounded time to rely on whether to pay premiums or not for meal period violations. Before 2012, the timekeeping system would automatically pay meal premiums for short, late, or missed meal periods, as reflected in the time cards based on rounded time. So there were some late or short meal periods that weren't being paid, that weren't automatically flagging that premium payment. After 2012, AMN started using a drop-down menu, also triggered on that rounded time, for apparently non-compliant meal periods. So the employee could choose between three options. They could say they had been provided with the opportunity to take a meal period within the first 5 hours of work, but chose not to. They could say that they chose to take a short or late meal period, or they could say that they didn't have the opportunity to take a meal period. And if they chose the first two options, they wouldn't get the premium, but if they chose the third option, AMN would pay the premium. However, again, it was only based on rounded time. So not all apparently non-compliant meal periods were being captured. The employees were also signing a certification statement at the end of each biweekly pay period saying that their time entries were accurate and that they've been provided with the opportunity to take all the meal periods they wanted to take. And if they didn't agree with that statement, they had the opportunity at that time to report any additional non-compliant meal periods. AMN argued that its practice of meal period rounding evened out over the time and was neutral to the employee. They argued that the rounding practice actually resulted in overcompensation of the class of 85 work hours, and that the average length of a nurse recruiter's meal period was 45.6 minutes. So based on that, they said their rounding was fine. Next slide, please. So there were two key holdings in this case. First, the court held that employers cannot engage in the practice of rounding time punches in the meal period context. And second, the court held that time records showing non-compliant meal periods give rise to a rebuttable presumption of meal period violations, and that that presumption applies at the summary judgment stage to liability, not just to class certification. Next slide, please. So we'll first talk briefly about the rebuttable presumption and how the court adopted it. The idea of the rebuttable presumption traces back to Justice Werdiger's concurrence in the Brinker decision. In that concurrence, Justice Werdiger wrote that under the wage order, the employer has the obligation to relieve the employee for a meal period and also has the obligation to record that the employer had relieved the employee. She also wrote that if there's no record of a meal period, then the rebuttable presumption arises that the employee was not relieved of duty and a compliant meal period wasn't provided. The Donohue court quoted Justice Werdiger's concurrence that an employer's assertion that it did relieve the employee of duty, but the employee waived the opportunity to have a work-free break is not an element that a plaintiff must disprove as part of the plaintiff's case in chief. Rather, the assertion is an affirmative defense, and thus the burden is on the employer as the party asserting waiver to plead and prove it. In adopting the concurrence, the court noted that several appellate courts had cited it approvingly. The Brinker also had held that employers are not required to police meal periods to make sure no work is performed, and the Donohue court reaffirmed that statement. AMN had argued that applying the rebuttable presumption would result in automatic liability for employers just based on time records alone. And the court said that wasn't the case, that employers have the opportunity to rebut the presumption by presenting evidence that they compensated for a non-compliant meal period or that employees had in fact been provided with the opportunity to take non-compliant meal periods. Next slide, please. So we'll go through a few practical ways that employers can consider in how to rebut the presumption. The first option is automatically paying meal premiums. This is something that AMN was doing to a certain extent before 2012. And this approach has some pros and cons. The benefit of this approach is that it helps manage potential liability in the individual and class context by just paying the statutory premium. But the drawback, one of the drawbacks is that it doesn't eliminate potential liability under claims brought under the Private Attorneys General Act for civil penalties. In Kim versus Raines, the California Supreme Court wrote that civil penalties a PAGA plaintiff may recover on the state's behalf are distinct from the statutory damages or penalties that may be available to employees suing for individual violations. So automatically paying the meal premium may eliminate statutory liability, but it won't eliminate potential civil penalties. Another potential drawback, well, another drawback is that paying the premium can result in an overpayment of premiums, since the employer is paying for premiums regardless of why the employee missed. So there'll be some instances where an employee may have chosen to work through a meal period and is getting the premium anyway. It can also result in employees trying to take advantage of the automatic payments by clocking back in a minute or two early, knowing that they'll be taking a 29-minute lunch and getting a full hour of pay. And that can result in performance management issues. Next slide, please. Employers can also consider using meal period attestations. The court in Donohue generally approved of the meal period attestations. They said that AMN's timekeeping system would have ensured accurate tracking of meal period violations if it had simply omitted the rounding. And the court also wrote, the employer is not required to police meal periods to make sure no work is performed. Instead, the employer's duty is to ensure that it provides the employee with bona fide release from duty, and this is accurately reflected in the employer's time records. That language suggests that a best practice would be for employers to incorporate that information on why there was a non-compliant meal period right into the time records, which using an attestation would help with that. AMN had also used a biweekly certification for the meal periods, and they argued that that was evidence that they had rebutted the presumption that there were no non-compliant meal periods. But the plaintiff argued that the timekeeping system only flagged meal periods that were short and late based on rounded times, and that as a result, she and other employees wouldn't have known about potentially non-compliant meal periods unless they had kept their own records. The court left that issue for remand, but noted that if employees had not known about potentially non-compliant meal periods without keeping their own time records, then the certifications would be inaccurate and would not rebut the presumption. The court reemphasized that it's the employer's duty to keep accurate records, and the employee is not required to rely on their own records to uncover potential violations. So that part of the opinion, it's worth considering in deciding whether to adopt a daily attestation or an end of pay period attestation. And for end of pay period attestation, making sure that the employee has access to their time records to review for any apparently non-compliant time punches. Next slide, please. The third thing an employer can consider doing is using representative testimony, surveys, or statistical evidence. This is something the Donohue court suggested. They quoted Brinker saying that this type of evidence can be used as tools to make manageable determinations of liability. However, an employer trying to use these methods should consider the dangers associated with that. One danger is, the biggest danger is that the employer will be conceding that there's a manageable way to try the case on a class basis. In Duran versus U.S. Bank, the Supreme Court wrote that in certifying a class action, a court must conclude that litigation of individual issues, including those arising from affirmative defenses, can be managed fairly and efficiently. In that case, the trial court had basically extrapolated liability based on a very small sample of 20 employees. There were selection bias issues, other issues, and the court had refused to consider additional evidence the employer tried to submit from 75 employees that painted a different picture of the work environment. And the Supreme Court had written, while representative testimony and sampling may sometimes be appropriate tools for managing individual liability in a class action, these statistical methods cannot so completely undermine a defendant's right to present relevant evidence. The effect of Donohue is to make the issue of whether or not an employee received a compliant meal period an affirmative defense. So it'll be important for employers to show that affirmative defense can't be tried on a class basis. So although this is one example of a way the Donohue court said employers could rebut the presumption, employers should be cautious about using this method. Next slide, please.
At this point, I'll announce the CLE code. So if you are interested in CLE credit, make sure that you write this code down. It is SS, as in Seyfarth Shaw, SS 7738. Again, SS 7738. At this point, we will turn the presentation over to David, who will walk us through a number of the best practices with regard to rounding and timekeeping attestations. David?
Perfect. So now that we've covered a summary of the Donohue decision and its key holdings, let's talk about some best practices when it comes to rounding meal and rest periods and timekeeping attestation systems. Before taking a deeper dive into rounding, though, let's rehash some basics. In California, employers are permitted to use a rounding policy for recording employee time as long as the policy does not consistently result in a failure to pay employees for time worked. So to be lawful, a rounding policy must satisfy two criteria. First, the rounding policy must be neutral on its face. And second, it cannot result in a systematic underpayment of wages over a period of time. Now, determining whether a rounding policy is neutral on its face is a rather straightforward analysis. All that is required is that the policy rounds time without an eye towards whether the employer or employee is benefiting from the rounding. The second factor, however, of determining whether a rounding policy will result in undercompensation over time is a tougher issue that can lead to rather unpredictable results. And I say that because when an employer starts rounding employee time, there's no real way for them to know whether the rounding policy will result in any underpayment of wages. The only way to make that determination is to wait until some time has passed and then analyze the employee's rounded punch times with actual punch times to determine the overall net effect of the policy. But because this is an arduous process that can lead to rather unpredictable results, the purpose behind rounding becomes more or less defeated, as rounding was developed as a means of efficiently calculating hours worked. Nevertheless, though, under the current landscape, rounding is still lawful. Since the Donohue decision came down, though, a lot of clients have been asking if the opinion is a precursor to the end of rounding. Well, the short answer is that the Donohue court expressly stated that it was not addressing the lawfulness of rounding outside of the meal period context. But we have to point out that the Supreme Court did go out of its way to point out that it has never decided the validity of rounding and that it has not adopted the rounding standards articulated by the Court of Appeals in the Seas Candy decision that we just covered. In addition, the California Supreme Court also suggested that rounding has likely outlived its usefulness and that technological advances now allow employers to track time more precisely. The court also made references to the fact that rounding policies appear rather pointless because it actually requires an employer to take the extra step of taking an actual punch time and rounding it to the nearest quarter hour or other increment of time. So in light of the Donohue's discussion of rounding, the practical advice we've been giving is that employers should move away from rounding if they haven't done so already. We believe that the Donohue decision is a warning to employers that the next time the issue of rounding comes up, the California Supreme Court will not only hold that it is unlawful, but that employers shouldn't be surprised by the fact that their potential decision is retroactive in nature. And so based on our recommendation or our prediction, we recommend that you take the time to eliminate rounding now to guard against future potential liability. Switching gears a little bit to best practices for meal and rest periods. Before we get to, my apologies. So I think it's worth spending a little bit of time talking about the backbone of any good attestation system before we get to that. So all good attestation systems must be premised on lawful written meal and rest period policies. Therefore, before thinking about your potential options for implementing an attestation system, we recommend that you review your company's meal and rest period policies to ensure that they're not only up to date, but that they also comply with the nuances of California law. We also recommend that you implement employee and supervisor trainings to ensure that your meal and rest period practices are actually conforming with your actual written policies. Your training programs don't need to be overly complex, and we have many templates and samples that we could easily modify for your company's industry and workforce. In addition to having these lawful policies and appropriate training programs in place, we recommend getting employee acknowledgments that simply state that employees received the policies, that they read and understood them, and that they were trained on them. This way, if you're ever faced with any claims alleging meal and rest period violations, you'll be able to easily show that employees were aware of and trained on your policies. Finally, we recommend that you ensure that the applicable wage order for your company's industry is posted in each of the company's locations or facilities. Not only is this required by law, but it also acts as another means by which you've made employees aware of their meal and rest period entitlements. Earlier in the presentation, Elizabeth mentioned that the court in Donohue held that employers cannot round employee time punches in the meal period context. So if you haven't done so already, please be sure your company has eliminated meal period rounding as soon as possible. In addition to the items we've already covered, employers should also consider some of the other options available to them to help limit meal and rest period exposure. These options include providing meal periods that are 35 minutes or longer. Although the law only requires employers to provide 30-minute meal periods, employers can limit exposure to short meal breaks of 28 or 29 minutes by simply providing employees with meal periods that are slightly longer in the range of 35 minutes up to an hour. In a similar vein, while the law only requires that employers authorize and permit 10-minute rest periods, another option for limiting potential exposure in the rest period context is to allow employees to take 15-minute rest periods. This, again, helps limit exposure to claims that employees did not get at least in that 10-minute break. In addition to meal periods that are short by a minute or two, we also come across meal period records that show a lot of breaks that are late by only a few minutes. Because employers need to provide a first meal period before the end of an employee's 5th hour of work, we suggest that meal periods be scheduled at least 30 minutes, if not an hour before then. Another tool you could think about using, and one that a lot of our clients have implemented, is the use of scheduling software that incorporates California's meal and rest period requirements to help ensure that all required breaks are scheduled in conformance with California law. This type of software not only helps take the guesswork out of the equation, but it's extremely helpful for supervisory level employees who regularly prepare employee schedules. As Elizabeth mentioned earlier in the presentation, another way to limit potential exposure is to automatically pay a premium whenever an employee records a non-compliant break. As she mentioned, though, while this option will definitely help limit exposure, it's not one that we necessarily recommend. This option is not only very costly, but in many cases will lead to the overpayment of premiums in situations where employees voluntarily decided to take a shorter late meal period or to skip it altogether. In addition, the automatic payment of premiums may lead to employee abuse, as Elizabeth mentioned, where if they figure out that they could game the system by taking a slightly shorter late meal break and, they'll be rewarded with an extra hour of compensation for their efforts, and that's probably a situation that you'd like to avoid. Finally, another option, and one we highly recommend, is that employers implement a timekeeping attestation system that will not only help increase compliance numbers and significantly reduce exposure, but it'll also avoid the additional costs associated with the automatic payment of premiums. For those who are unfamiliar, a timekeeping attestation is something that could be integrated into your current timekeeping system. When you have a timekeeping attestation, the timekeeping system will generate various prompts that ask employees to attest whether they have been provided with compliant meal and rest breaks, and also whether they have accurately recorded all hours worked. While the Donohue decision doesn't require employers to implement this type of system, we definitely believe that best practices do. And if you're interested in implementing a timekeeping attestation system, there are a range of ways to approach the process, with some options providing more protection than others. Keep in mind, though, when developing an attestation system, you'll want to consider the limitations and abilities of your existing timekeeping system, as not all systems can do all things. Now, what should an attestation cover? Well, the ideal attestation will prompt employees to certify that the hours that they have recorded accurately reflect all of the hours they have actually worked, and also to certify that they were provided with compliant meal and rest periods. Now, I know this probably sounds like a lot, and we've covered a lot of ground in a short amount of time, so I'm assuming the next question you probably have is, why should I even consider going through the effort of implementing an attestation system? Well, as we've kind of covered before, an attestation can help with a few things. It can help reduce potential exposure for facially non-compliant breaks without the additional costs associated with the automatic payment of premiums, because with an attestation system, it will ask the employee to confirm whether any non-compliant meal or rest periods were voluntary or involuntary. And in this scenario, premiums are only paid if the employee attests that a missed late or short meal period was involuntary in nature. An attestation system also helps an employer create a record to help overcome Donohue's rebuttable presumption from meal periods, as well as potential claims for off-the-clock work. This way, if you were ever faced with a lawsuit, you already have a lot of helpful evidence to help defeat the claims asserted without the cost or expense of conducting multiple witness interviews and gathering employee declarations. Attestation reports that can be generated by your timekeeping system also allow you to conduct periodic audits of the attestation records to help spot employee abuse and compliance deficiencies before you're faced with a potential lawsuit. I know we saw some of this language from the Donohue decision before, but you might be asking what a typical attestation looks like. In the first bullet point here, I've provided an example of a basic attestation that asks the employee to attest that their time records accurately identify all hours worked and that the employee was provided with all relevant meal and rest periods. As a result of Donohue, I think employers should consider adding a second sentence to this type of attestation, such as, I was not required to miss any meal or rest periods, or to take short or late meal or rest periods, and that any short or late or missed meal periods were a result of the employee's voluntary choice. As I mentioned earlier, attestations can come in many different forms, and I kind of just wanted to walk through an example of a meal period attestation. So when an employee goes to clock out for the day, the employee will be asked if they were provided with all relevant meal periods as provided in the company's written policies. If the employee selects agree, then the process ends and the employee should be clocked out for the day. However, if the employee selects disagree, additional screens should prompt the employee to answer more specific questions regarding their meal periods. For example, your attestation system may include a drop-down menu that allows the employee to identify if the issue was a missed, late, or short meal period, and also whether it was voluntary or not. If the employee selects that it was voluntary, in that situation they wouldn't be provided with a meal period premium. But if the employee selects that it was involuntary, whether it was because their manager asked them to return from their break early, or if it was interrupted in some way, then the employee should be able or should be provided with a meal period premium in that instance. Another option in the meal period attestation context that we consider an enhanced approach is the flagging or highlighting of non-compliant meal periods. For example, if an employee goes to lunch and comes back and tries to clock in a few minutes early, the system will flag the issue and ask the employee whether they mean to clock back in early, and if so, whether they are doing so voluntarily. In this scenario, like before, if an employee selects that they're returning voluntarily, they wouldn't be provided with a premium. However, if the employee selects involuntary, in that instance, they would be provided with a meal period premium. Before wrapping up today, I wanted to touch on a few other questions we've been getting from clients. The first is, should an employee's time and corresponding pay reflect the time spent completing the attestation process? Absolutely. The employee's final punch-out time should be after the conclusion of the attestation procedure, and time spent completing the attestation should be paid. Another question we've been getting a lot is whether attestation should be done daily, weekly, or at the end of each pay period. And as Elizabeth mentioned earlier on in the program, while there isn't really a right or wrong answer here, we believe that attestations are strongest when they are daily. Finally, we've been asked a lot whether employees should be able to view the time punches they are attesting to. And again, as Elizabeth touched on earlier, we believe that they should. You know, for employees to be making an you know, to be able to attest to their records accurately, we believe that they should be able to view all relevant time punches for the period that they're attesting for, including all punches in and out for meal periods.
Thank you, David. We have just a few moments left, and so quickly we'll try to address at least one of the questions that came in, which is the intersection between the Donohue decision and the Supreme Court's earlier decision in the Starbucks Troyster case. Just a quick reminder for people, in that earlier case, the Supreme Court effectively held that the de minimis doctrine in California no longer applies. That's a little bit of a simplification, but the practical effect is essentially that. And so the question is, if the de minimis doctrine isn't in play in California, what does that mean with regard to rounding of meal periods? Well, the first answer to that is, under the Troyster decision, if you were to have a meal period that is, for example, 29 minutes in length, that would be a facial violation in terms of a short break in California. The second part of this, and frankly a very interesting question, is all timekeeping and payroll systems, almost by definition, round. Nobody uses an atomic clock for their timekeeping and payroll systems. And so what the Supreme Court decisions simply don't take into consideration is that, by definition, every system rounds in some fashion. And most systems round at least on a minute basis or a 30-second basis to the minute. And so the question becomes, in doing so, is that a violation? Well, the Supreme Court chose not to address that question. And so the simple answer is certainly anything above a 30-second round the Supreme Court is likely to find to be problematic, but they left open the question as to whether or not that 30-second period would be still of such a short duration as to satisfy the very, very minimal amount of what's left of the de minimis doctrine in California. Unfortunately, that takes us to the end of our time today. We do want to thank everyone for logging in and joining us. Again, if you have any other additional questions, feel free to reach out to myself, Elizabeth, David, or any other of the Seyfarth lawyers that you are working with. And we would be more than happy to follow up with you directly. Thank you very much again for joining us.